So today I want to go over a musical copyright case, actually two of them, that both of which I think were decided incorrectly. The first one is Bright Tunes versus George Harrison. Now, Bright Tunes was a music company that owned a hit single by the Chiffons called He's So Fine, and the George Harrison song in question was My Sweet Lord. So anyway, the Chiffons in 1963 came out with He's So Fine, and in 1970, George Harrison came out with My Sweet Lord. And before I go any further, what I'd like you to do is click on the link below. You can listen to the two songs together, and you can determine whether or not you see any similarities between them, and if so, do these similarities amount to musical copyright infringement? All right, so you've had a chance to listen to the two songs. And I think you'll probably be surprised to find out that the judge in this case ruled that George Harrison had infringed the copyright of the Chiffons' He's So Fine. And the judge in his ruling said, I'm gonna read this. It is perfectly obvious to the listener that in musical terms, the two songs are virtually identical. And the judge ruled that George Harrison had subconsciously copied the Chiffons' He's So Fine. So I don't know how you subconsciously copy something. And the judge looked at two aspects of George Harrison's access to the source material, He's So Fine. The first thing is he looked at access. Did George have access to it? And George said, I've never been to a Chiffons concert. I've never heard the song before, but I listened to the radio, so it's perfectly logical that I could have heard the Chiffons music. And then the judge looked at the similarity between the two. He said, you've got to look at how much of the first song was copied by the second song, and there's basically three notes. And so the three notes make the songs virtually identical. So anyway, you might want to re-listen to the songs below and see if you think that three notes that are the same should basically constitute subconscious copyright infringement. I should also point out that these three notes are they're two notes away, but the same basic scale of Let It Be, the bridge on Let It Be. So yeah, I didn't hear Paul McCartney and John Lennon hassling George Harrison about My Sweet Lord over Let It Be. But anyway, in this case, George Harrison was ordered to pay $587,000 for subconsciously plagiarizing He's So Fine. Now, this gets kind of dirty here, and it's a good exercise in what lawyers should do and what lawyers shouldn't do. The Beatles at one point were, well, at least 3/4 of the Beatles were represented by an attorney named Alan Klein. Paul McCartney decided he didn't want to be represented by Alan Klein, but instead he wanted to be represented by the father and brother of his then wife, Linda Eastwood. So 3/4 of the Beatles were represented by Alan Klein. During the time that Alan Klein was representing the Beatles, he attempted to buy the He's So Fine copyright from Bright Tunes. And anyway, then the Beatles fired him. He apparently wasn't very happy about this, and so he continued to negotiate with Bright Tunes to buy the copyright, which he then used against George Harrison. So if this isn't a conflict of interest, I don't know what is. Anyway, the judge saw through this and said, hey, this is a pretty bad conflict of interest. So, George, I'm going to order you to pay to Alan Klein exactly what he paid Bright Tunes for the song, which was $587,000. So in the end, Bright Tunes made $587,000. George Harrison lost $587,000. And Alan Klein made nothing other than to become one of the more hated people in the music industry. But the net result of this, the being found guilty of subconscious plagiarism, really threw George into kind of a bad mental state. And he said that for quite a while afterwards, he hesitated to even pick up a guitar or play the piano because he was afraid that he might subconsciously plagiarize someone else's music. So anyway, I think this was the wrong decision. I don't think he should have been found guilty of subconsciously infringing the copyright of He's So Fine, and I think the judge made the wrong decision. So now we're going to turn to another case. Okay, the next case I want to go over is between the heirs of Randy Wolf and Led Zeppelin. And so this is basically a lawsuit between, the actual recording is an instrumental piece called Taurus by the band Spirit, and Randy Wolf, better known as Randy California, was a member of Spirit who wrote the instrumental Taurus. Led Zeppelin is a much more famous band, and they have one of their most famous musical works is Stairway to Heaven. And the heirs of Randy Wolf allege that the opening instrumental to Stairway to Heaven is infringibly similar to part of the Taurus song. So what I'd like you to do now is go to the link below and take a look or take a listen to Taurus. The allegedly infringing portion begins around second 18 of their recording, and compare it to the opening riff for Stairway to Heaven by Led Zeppelin. Okay, so now that you've had a chance to listen to the two songs, let's go over some of the facts here. So Taurus was written by Randy Wolf, who is known better as Randy California in the group Spirit. He wrote Taurus in the late 1960s. Randy died in 1997, and Randy's heirs brought a lawsuit against Led Zeppelin in 2014. So let's look at the access. You can make your own decision on the similarities and whether or not there are more similarities between Taurus and Stairway to Heaven, more than the three notes in George Harrison's My Sweet Lord. Anyway, now this is a funny one because Led Zeppelin ended up being one of the more famous rock and roll bands from the late 1960s, early 1970s, and I think they're still going now. But anyway, when they were beginning, they weren't that big of a deal, and so Led Zeppelin actually was the opening act for Spirit on at least 3 separate occasions. So they opened because Spirit was the bigger band. So according to Spirit, this was clear access because they Taurus was one of the songs they said they played. So Led Zeppelin presumably hung around and listened to Spirit. So anyway, according to the heirs of Randy Wolf, Led Zeppelin had plenty of access to the song Spirit. Anyway, Randy's heirs sued in 2014. The trial concluded in 2016, and the jury, with 1 hour of deliberation, found that Led Zeppelin was not guilty of copyright infringement, and that the Taurus song's riff was not intrinsically similar to the opening of Stairway to Heaven. Okay, juries are juries. There are probably an awful lot of people and companies out there that question a lot of jury decisions, but in this case anyway, I think that during jury selection, the attorneys representing the heirs to Randy Wolf might have asked, so juror, do you take magic mushrooms on a regular basis? Do you promise not to take LSD during this trial? Because this, not intrinsically similar? You gotta be kidding. Anyway, so according to the attorneys for Randy Wolf, that they said that Led Zeppelin basically rips people off all the time. They said that Led Zeppelin covered another Spirit songs, and that it listed 16 other Led Zeppelin songs that were show a history of lifting composition from blues artists and other songwriters, and that Led Zeppelin never credits anyone when they take something from another song. This seems to be fairly good evidence. Randy Wolf's attorneys also made a few pretty, I think, not so strong claims. For example, they said there's Led Zeppelin used a musical instrument that Spirit used. Well, okay, the Beach Boys used it too. The theremin. It's you can hear it in good vibrations. So anyway, I don't see that as being a very strong claim. Now, in the case against infringement, Jimmy Page of Led Zeppelin said he didn't hear Taurus until 2014, well after the date that he wrote Stairway to Heaven. So, okay, so if he didn't hear it, maybe they didn't hang around at the concert when they opened for Spirit. Maybe they all got in their bus and went on to the next venue. Anyway, he claims not to have heard it. And then his lawyer, Led Zeppelin's lawyers, make a number of claims that kind of seem to undercut this initial claim that they didn't have access to the work. They claimed that Taurus was a work for hire, that Randy Wolf didn't own the copyright. They also quoted an interview with Wolf from 1991 where he stated, "I'll let them have the beginning of Taurus for their song without a lawsuit." Well, okay, if he told them that early on, then they must have known about Taurus, right? Okay. So I don't. They also make a bunch of arguments about no deposit copy being left with the U.S. Copyright Office and some other things like that. Their best claim, I think, is something called latches. Latches is a legal defense where you say, if you took too long to bring this lawsuit, you should lose the lawsuit just because it's not fair for me to have to defend this thing. And in this case, they point out that the heirs of Randy Wolf brought this lawsuit 43 years after these songs were written. And I view that as a very valid claim because, I mean, I know 43 years ago, you know, I think I'm probably trying to get into law school or something like that. If you asked me, so Eric, what essay did you write to get yourself into Hastings? I don't even remember writing an essay. So I'm certainly glad that nobody's quizzing me on what I was doing 43 years ago. So with that in mind, I think that the way that I would have resolved this case is I would have found Led Zeppelin guilty of copyright infringement because I think, first of all, they had access to this song. Second of all, the amount that they copied was significantly more than George Harrison supposedly lifted from the chiffons He's So Fine. But I would have said that the heirs of Randy Wolf have no claim for damages because of latches. You took too long to bring this lawsuit, and if Randy Wolf personally had brought it, say, a year after Stairway to Heaven came out, then I'd say, okay, I think you got a valid lawsuit. But asking Led Zeppelin to try to come up with facts from over 40 years ago to support their case, that's simply not fair. So again, I would have come down on this a little bit differently. Now, I want to end this as long as we're talking about musical copyright. And again, I'm not an expert here. In an earlier video, I admitted to not being able to name a single song by Lady Gaga, Bad Bunny, or who's that? Kid Rock. Kid Rock, like, how old is he? Shouldn't be like senior rock or something like that. Anyway, whatever. I can't name a single song by any of those people. But I want to conclude this with two sets of songs where I think one is obviously a lift of an entire riff from one band to another, and the other I'm going to call sort of an inspirational performance that kind of does honor to another song but doesn't exactly copy it. So I'm going to put links down there below. And so the first one is Bryan Adams' The Summer of '69 against Green Day's Jesus of Suburbia. Now, obviously, these are two entirely different artists with entirely different ways of singing, ways of performing. But I'll let you look at the link before and see if you think that this is more than George Harrison's 3 notes, or perhaps it's less than Led Zeppelin's entire opening. So you can decide whether or not you see too many similarities. The second set of songs I want to go over is again Green Day. They have a song called Last Ride In, and I think this sounds remarkably similar to the theme song from The Endless Summer. And but I would not rule this to be copyright infringement. I would say that The Last Ride In by Green Day was inspired by The Endless Summer, but I wouldn't consider it copyright infringement. So anyway, why don't you listen to the two below and come to your own conclusion. Just as a final note, I have a personal connection with Bryan Adams' Summer of '69. Before I was a patent attorney, I was a competitive kayaker, and for about 3 years I went around, entered kayak competitions. Never made any money, but I had a good time doing it. Anyway, I was in Dublin in 1988, and I was on the U.S. national team, and my job was to go into Dublin and get the boats for the team from our sponsor, Perception Kayaks, and ship them all over to kayak retail outlet in Dublin. So I'd go in there and get them. And I'd never traveled internationally before. I'd never been on a 747. So I was totally jet lagged by the time I got to Dublin. So I stayed in the hostel because I had no money. And I was just going to wait till the next day, and I was going to go in the shop, and they were going to have a guy drive me to the contest site with all the boats. So I'm sitting there in like probably the second floor of a hostel, and on the bottom floor there's a bar and a band is playing, and the band was actually quite good. They were an Irish band. So from my perspective, they sung with a really funny accent, but all the patrons seemed to really like it. Anyway, they'd apparently just gotten together because they didn't know, all the members didn't know a whole lot of songs. And the three songs they seemed to know the best were Summer of '69, Bohemian Rhapsody by Queen, and Yesterday by the Beatles. But anyway, Bohemian Rhapsody and Summer of '69 went over much better because apparently the crowd didn't like the kind of the softness of Yesterday, and they were playing it all with electric guitars, so it wasn't kind of like Paul McCartney getting there on his acoustic guitar and singing the whole thing. So anyways, as the night went on, for those of you who don't know, Bohemian Rhapsody by Queen is one of the most difficult songs to sing, and Freddie Mercury, the late Freddie Mercury, formerly of Queen, he had a 4-octave vocal range, so he could sing it. Well, the lead singer for this band did not have, he had like a 1-octave vocal range. So he was trying to cram all of Bohemian Rhapsody into about 8 notes that he could sing. So it didn't go that well, but everybody in the band knew their parts. So at the end of the performance, he would say, "Do you want to hear another?" And everyone would go, "Yeah!" And so they started with Yesterday, and everyone's kind of like, okay. So then he does Bohemian Rhapsody. By this time, the guy's voice is just completely shot. And so they're going, yeah, yeah. And then he goes, then he plays Summer of '69 again. And everyone's like going, ape, you know what, and clapping like crazy. And so he says, "Do you want to hear another?" And they go, "Yeah." And I've got the pillow over my head. I'm going, no more music. It's like 4 a.m. And so he starts off Bohemian Rhapsody. His voice just cracks, and he gives up. He goes, "You want to hear Summer of '69 again?" And everyone goes, "Yeah." So he plays Summer of '69. And then he goes, "Do you want to hear it again?" "Not, do you want to hear another song? Do you want to hear Summer of '69 again?" "Yeah." And this goes on. So he played Summer of '69 probably 4 times. And I've got the pillow over my head. And they finally quit, probably 4:30 in the morning. And then afterwards, the band's packing up their stuff, and all their fans are going by, "Hey, you guys were great." And they're all shouting outside. So about 5:30, I could finally get to sleep. And by that time, it's like 10 o'clock California time. So I'm not even sleeping. I just woke up and, ate some peas or something like that. I was a strict vegetarian at the time, so I couldn't eat hardly any of the food over there other than potatoes and peas. And then I went over to the place that was storing our kayaks and got them over to the contest site. But so anyway, that's my personal connection to the Summer of '69, and I don't ever want to hear anyone shout out, "Do you want to hear it again?" because my answer is no.